is you can't tell the cell tower people, no, you can't put it here, you know, kind of deal. You regulate how they put it in, but you can't tell them basically no, because the feds say that, you know, that's interstate commerce.
Because
You know,
FTCs,
if you want to have one of these things, you know, you got to be able to have towers, and therefore the federal government's going to regulate that, not the locals.
they trump everything, yeah.
Well, that's about the way it is. They do trump everything on that. Also, remember, you know, the classic is use variances. They'll come in and say, well, you know, I always like the one where you can only have a single-family house on the lot. And they come in, and I don't know if you've seen this, but they come in and go, well, my father-in-law just died, and we've got to move my mother-in-law into the trailer over here, or my wife, or my sister, or, you know, just lost her husband, or my daughter's husband just ran off with a barmaid, or my, you know, all the reasons you can think of, you know, I got to move this trailer in just for a little while, you know, until they get on their feet, and then I'm going to move that out. Move that out. Well, you know, that's not a variance you can grant. It's called a use variance. And the zoning ordinance says you can only have one principal structure. That'd be another principal structure. You can't grant that kind of variance. It's not possible. There's no provision under your zoning ordinance to allow that. There's no provision under the state law to allow that. That's a use variance. It cannot be granted. Now, this is what you can do if you have a bunch of those. And the state's already done it for one thing. They have a medical unit now that they passed a law that allows the county to allow these small medical, you know, trailers or facilities to be put in the back of a lot, so that, you know, the mother or mother-in-law, father-in-law, or somebody, elderly person, can be there and be monitored and have a separate living facility there on the lot. And then after the person does die, the law says the state law says it has to be moved. And that's the way after they die. Yeah, or no longer needed. Maybe they have to go to another facility or something. That carries only for those medical situations. And there's a statute that covers it. They came actually out of Knoxville once upon a time. But the ones on my daughter, you know, husband ran off, or my son's wife ran off, or, you know, Aunt Martha needs to move here or something, not medical, but just for a reason they need a place to live, you can't grant that type of variance. It's not possible. It's called a use variance. So somebody comes in and says, you know, I have this piece of property, and the zoning ordinance says, you know, I can put a grocery store there. I won't be able to put, you know, a gas station there. Can I have a variance to do it? No, you can't. You know, that's a use variance. You can't grant a variance. If you have a lot, I used to tell boards of zoning appeals, they used to have a lot of variances on canopies at gas stations, where, you know, you can pump your gas and not get wet, and they're already too close. They'd be too close to the right-of-way, you know, and they'd come in and want a variance. I said, well, you can't grant that variance. But if you keep having these type of situations developed, then the Board of Zoning Appeals should talk to the Planning Commission to say, look at the provisions of the zoning ordinance. Do we need to make some changes? Because all this is happening, you know, we see it way too often. Do we need to change the zoning ordinance? And then if they think they do, then it goes to the county commission, and, you know, they can take care of a lot of situations that are repetitive, that's due to a provision of the zoning ordinance that may or may not be valid anymore. So, you know, it's also your job sometimes to raise that flag and say, look, you know, here's a provision that's giving everybody problems. Do you think we need to look at it? And remember, you can't grant, and I've heard subdividers do it all the time. I'll go to the Board of Zoning Appeals on this new subdivision and get them to give me a blanket variance on the front setback line. Well, you can't do that, period. The Board of Zoning Appeals does not have that power, because that's a newly created situation. The judges say, any man-made condition cannot be granted a variance. Monetary considerations are not part of the deal. You can't consider how much it's going to cost in order to grant a variance or not grant a variance. It has to be based upon that shape or topography of that piece of property that was in existence at the time of the zoning ordinance. So that means no new created lots can be granted a variance.
Mike, on that medical variance on a unit to live in, were there restrictions on the size of that medical unit?
That particular law for the medical unit, is that the one you're talking about? Yeah, I think it's something like 500 square feet or something like this.
So they couldn't put in 2,000?
Pardon?
They couldn't pull in
No.
a triple wide trailer?
No. It's a self-contained little unit.
So it's a pre-engineered, prefabricated
Right.
thing that's being brought in by some outside organization.
So it's a national.
That's the first I've heard of that.
Yeah, there are people that are manufacturing these things, and it's, it has all the little,
So it's an actual medical unit with a bed and,
yeah.
okay, it's not
It's a
really a
per-
living space, but that is.
Yeah, it is, it's a facility for them to live in, but just because of the medical conditions, and it has certain features in it because of the medical conditions.
So you can't pull your own thing in and say it's a
No.
medical, okay.
No, it has, the section of the statute has some of the requirements. I don't recall them off the top of my head, but they have some of the requirements of the structure, and it even talks about it has to be approved by the NAA's, IC, KOP, whatever group looks at those things,
So are they inspected when they're set up by
Yes.
the state fire marshal's office?
Well, I don't know about that, but
Because
they
they
are
inspect
inspected.
mobile homes, so.
Yeah, they are inspected when they are manufactured. So,
As a part of this training session, could we tonight get an update on downtown Wallen and Blackberry and the new development that's going on East Miller's Cove Road?
After we get done with this,
All right.
off the record, because I think this is being recorded. That's why I hadn't said any bad words. I don't think.
You're all right.
You'll bleep that, right? Well, according to my watch, I've got 3 minutes to answer questions. I don't want to waste your time. If you pay me for 3 minutes, I want to.
I've enjoyed you being here. It's been interesting.
Well, good.
What is the one biggest thing a BZA needs to learn?
Well, I think you need to learn that, the biggest thing is to ask questions.
Okay.
To be able to say, I need more information about this, especially if it's something that, you're looking at as does it fall under one of the extra provisions of the law, like the non-conforming grandfather statute, or the Religious Group Act, or the one that's there on the agriculture. Don't be afraid to ask a question and say, I don't know at this point in time. We need more information on it. Now, the other thing is that you have to realize that you're not going to make people happy, especially in these variance situations. Where you're limited, and so therefore, you have to cut the line here. So that's a big takeaway. Know that you can't grant a variance just because somebody wants it, kind of deal. Also know that on the special exceptions, if it's not in your written word in your zoning ordinance as a condition, you shouldn't be adding anything else to it unless you've asked the planning commission. Sometimes I tell people, you got to swallow that bitter green pill. I don't like what I'm having to vote on. I don't like this is the decision I'm having to make, but they meet all the conditions that's in the book right now. I don't think it's good, but they're meeting everything. Therefore, I'm going to have to vote on it for it. Doesn't mean that later on that I can't meet with the planning commission and go, we think there needs to be more conditions put on this. Would y'all look at amending the zoning ordinance to add conditions?
So there ain't nothing wrong with going back and asking the planning commission, this ain't right. look at that again.
No, I mean,
That's-
either they are, ultimately, the planning commission can only recommend to the county commission.
Right.
So, sometimes you have to tell the county commission why something's needed in through there too. But, these are documents that should not be, shall we say, written in stone. You need to be able to revive them a little bit. You need to change with the times a little bit with them. There are uses right now that when I was a practicing planner a long, long time ago, before when the earth was cooling and all that, there was no such thing. This use was not even dreamed of, kind of deal. So you have to look at these things. I always tell people, GM, when they came into Murray County down there at Spring Hill, they said, we're not going to come unless you enact a zoning ordinance. And who in Spring Hill and Murray County and in southern Williamson County would have ever dreamed 5 years before they were there that they were going to come and build a plant like that, So conditions change, and you have to be willing to look at those changes and see what's the best for your community, because nobody can tell you what's the best for Blount County. Only you know what's best for Blount County. Somebody from Nashville or Lebanon or somebody else, I can't come in and tell you what's good for Blount County because I don't know. I come through here all the time, but I don't know. This is your home. And therefore, that's, where you have to concentrate on what is good and what you need to be looking at. So I think the big takeaway is realize that it's more to this than just listening to a couple of people complain about something or asking you to do something. Sometimes you have to ask, not necessarily you all the time, I hate to say this, but sometimes you have to ask the planner, you have to ask the county attorney, what is this? Is there some provision over here that we need to look at? Kind of deal. And, they pick up the phone and they call people like me and say, well, what do you know about this? And either I do or I don't, and if I don't, then I'll say, well, go call somebody over here. There's always help out there, and don't be afraid to ask for it. I'm not for sure that, everybody always knows everything they need to know. And, a little education doesn't hurt. The lack of it can cause problems. And, bless their hearts, don't worry about these that are up here moaning and groaning, complaining to you. Because most of the time what they're complaining about has no basis. It's a factor of fear of the unknown. They're not telling you anything based upon a fact. They're telling you things based upon a speculation. If somebody comes up, and there's a difference between a speculation and a fact. If they give you good, solid information, good, solid evidence, that's one thing. But just telling you, we don't want this here, that's not a reason to do it. I always tell people, everybody complains, I'm going over, everybody complains about property rights. I have my property right, I have my property right. Well, developers have their property rights too. And people that own property have their property rights. And yes, I built this house and I like to see the green pasture over there and the deer running across. And unless the county buys it or I buy it, somebody eventually is going to use that property for something besides green pasture with deer running across it. And I have to realize what that is. And I have to also tell people, look, before you buy a piece of property or, pay attention to what, there's something called constructive notice. Pay attention to what the county says can go in a piece of property. Because that's the only way, people need to do their own homework. No. All right. That's what I recommend. People do it both ways, but I recommend doing it where they get it at the meeting.
So when else you got
But I mean, that's y'all, I'm just saying what. Y'all, y'all do what you need to do. Yeah, it's your decision. Yeah. Ex parte communication, fairness, doctrine, being able, the law says you should make your decision within the four walls of the meeting, everybody hearing it at the same time, that type of situation, that everybody knows everything at the same time. Nobody has, kind of a heads up information. Yeah. Yeah, he can do that. Yeah, it's the decision makers. The decision makers are supposed to make the decision with the confines of this room, hearing the evidence that's presented to them at the time it's provided to everybody. Staff, on the other hand, is supposed to prepare the documents and the information for you to review. That's their job, kind of deal. So that's my, the old saying is, you're paying me for my opinion, you're not paying me to take it. Okay? Well, see, that can be done right here. That can be done right here. Every piece of property can be shown right here in this room. And, and I base that on a lot of different things, but, the courts have basically said to you as a body that, you're supposed to make your decisions based upon the evidence presented to you, not upon evidence you gather outside of the room. That's what the courts say. I'm only repeating what the courts tell you to do. And the courts have told themselves that. I know a chancellor who went out and looked at a piece of property, and the Court of Appeals overturned him for that very reason. Well, taking those phone calls and not taking that information when somebody stops you at Ingalls or church or Walgreens. They'll call you at 9 o'clock at night before you're trying to watch the news or whatever. You don't need to be hearing information outside of this room, and everybody needs to hear the same information at the same time. Now, that's the fairness doctrine of it all. You all have to make a decision on how you run your own meetings. I'm only giving you my advice on how to keep it clean and how to do it the best way that you're supposed to do it. Now, I'm leaving and going back to Wilson County. So what happens in Blount County after that is up to y'all, But, again, I did. Twice, not just once, but I've been up here twice for y'all. Sure. Well, if 15 minutes from now you hear somebody going, help, help, I'm lost in the hall.